Small business is big business. The sponsor of today's episode, 𝐬𝐮 Bank, understands that small businesses are the lifeblood of our economy. For more than 150 years, 𝐬𝐮 has remained a dedicated partner to those businesses and entrepreneurs who bring vibrancy to the local community. Through sound advice and simplified solutions, 𝐬𝐮 proudly supports small businesses. For an array of business solutions tailored to your specific needs, visit 𝐬𝐮.com, BUSEY.com. And if you're seeking a business acquisition loan, be sure to reach out to the head of their SBA group, Steve 𝐿𝐴ZOWITZ. Steve's somebody I've known for almost 15 years. He's one of the best SBA bankers out there, bar none. And you can reach Steve at steve.lazowitz@busey.com. That's Steve, STEVE, .lazowitz, LASIEWICZ @busey.com.
Looking to buy, sell, or grow your business to position it for a sale? As the owner and managing partner of Sun Acquisitions, Dominic Rinaldi has personally been involved in over 300 M&A transactions. He has seen and done it all, consulting with large and small businesses across a broad range of industries. On M&A Unplugged, he'll interview buyers, sellers, and their advisors about their experiences scaling, selling, and acquiring businesses. On every episode, you will get key learnings, but most importantly, you will be better prepared for your own acquisition or sale. This is M&A Unplugged with your host, Dominic Rinaldi.
M&A Unplugged community, I'm pleased to have Jeremy Waitzman with us today, a seasoned corporate attorney with the law firm of Sugar, Felsenthal, Grace, and Helsinger. I've known Jeremy for many years, and we've had the opportunity to work on M&A transactions together. Jeremy was trained as a corporate M&A deal attorney, and his experience is expansive, having been involved in over 150 transactions. Jeremy, that's a lot of transactions.
Keeps us busy.
He's also a frequent speaker, panelist, and moderator on the issues related to mergers and acquisitions. He's also one hell of a nice guy and well respected by his clients and colleagues. Jeremy, welcome to the M&A Unplugged podcast.
Thanks, Dom. I appreciate you having me.
Absolutely. So let's start with, give the M&A Unplugged community a little backgrounder on yourself, on your firm, some of the things that you specialize in.
Yeah, absolutely. So as you said before, I'm kind of a corporate guy, right? So everything from I want to form a company, I'm going to raise money, clearly M&A, succession planning, and issues related to the like. Sugar Felsenthal has been around for over 35 years. Clearly, I was not with them when they started. But it started as kind of a tax and estate planning firm. And as, kind of the clients matured and needs arose, they grew. And now today we're 30 attorneys, kind of headquartered here in Chicago. We also have an office in New York City. But it's kind of the general corporate business law firm, everything from the corporate stuff that we do to litigation, estate planning, real estate, kind of your broad, we like to say, we can handle 95% of, kind of what a business or business owner would need either on the business side or personal side.
That's great. That's great. And what are you seeing in the marketplace right now in regards to transactions? Our experience right now it's never been hot. All my years of doing this, I've never seen a market that's hotter than the one it is right now. What are you seeing?
Yeah, I think we're seeing the same thing. It's steady and people want to do deals. They're between, kind of the private equity family office money still that's out there and available and folks that are perhaps looking at an exit event. It's still healthy out there.
Yeah, and it doesn't seem to be slowing down, does it? Amazingly, we just brought a deal to the marketplace. HVAC, heating, ventilation, air conditioning, and we've got over 60 buyers that have expressed early interest in taking a look at the deal. It's unbelievable.
Yeah, that's crazy. That's great.
Yeah. So, Jeremy, I thought today we could spend some time talking about the things in a deal that go beyond price. Oftentimes, I say this and I hear people like you, I know you've said it, and other people say that, it's owners will many times not pick the offer with the highest price because there's so many other terms and conditions that need to be considered. And it's interesting when people first get the offers and they look at the price, they're like, oh, this guy, this firm or this peg or this strategic looks like, they really want the deal. But then you start to dig in and you read through the rest of the terms and conditions, and there are, lots of loopholes and shackles and all other things that, can concern people. And so I know you've experienced this. So why don't we talk about that a little bit at a high level, and then maybe we could drill into, what are some of the specific things that owners need to worry about in an offer that go well beyond price?
Yeah, certainly. I mean, look, from a high level, even outside of the legal terms themselves, I mean, if somebody's ready to move on in their business or sell their business, there's factors behind that. It's not just I need this cash windfall. They're tired. They're ready to spend time with their grandchildren. There's something else they want to do, and oftentimes business owners have been doing this and only this for years, 30, 40 years. Maybe they started it in their 20s and now they're in their 50s or 60s and they're just done. So it's a mental mindset there that they want to perhaps explore or move on to the next thing. In context of the legal terms, oftentimes, as you said, Dom, it's not just about price. It's about, I want to take care of my employees. I want to make sure that when I'm out, things along those lines. So I think when you're talking at the 30,000 foot level, it's what are you trying to accomplish and how do you get there?
Yeah. Yeah. And it could also be when I'm out, I want to still keep a foot in, right?
Yeah, right. Absolutely.
I want to take some chips off the table, but I'd like to stay involved. Like, so there's all flavors of what can happen, and the conditions of those really matter. So that said, why don't we dive into some of the areas that you see that consistently come up that go beyond price that, owners really need to care about?
Sure. So let's talk, first about kind of the business terms, right? Oftentimes lawyers kind of stay out of that fold, and you come up with the business terms and tell me what they are, and I'll get it in the document, right? But there's terms. Let's talk about something like payment structure. It certainly could be all cash, which is often the preferred method for sellers. But what if there was a situation that maybe you get a little bit less at closing, but could get future upside? That could take the form of kind of some kind of earn-out structure, meaning if certain benchmarks are hit, whether it be sales or otherwise, that you as the seller can get additional cash. It could be that you get what's called rollover equity, meaning you take some stake on an equity basis in the continuing entity. So you get a cash out where you sell 100% of your company, but you're retaining 1 or 2 or 5 or 10% of the resulting entity, and so you're a shareholder. Instead of being the boots on the ground there every day, it's a passive income kind of stream. So sometimes people get to what's called double dip. So there are other things on the business side that may come into play.
So let's talk about those two things for just a little bit. I mean, we could spend an hour really digging into both of these. So we'll keep it at a high level, but enough to give the M&A Unplugged audience an understanding. Earnouts, right? Not all earnouts were created equal. They could be fraught with challenges. You want to make sure you do them in a way so that you don't wind up with litigation later on, right?
Right.
Because, earnouts can easily lead to that. And that is one of the, downsides to an earnout and why a lot of people don't want to go there. But they're a very viable additional term in a deal. So what are some of the high level things when you're advising a client that you tell them to be negotiating for or looking for when it comes to an earnout?
Clarity. Plain and simple. As you said, Dom, it's one of the most litigated areas of M&A is whether or not somebody's entitled to a payment pursuant to an earnout. And where you get into trouble there is where you use ambiguous type terminology. It's much better to say sale of X units, right? If you sell 5,000 widgets, you're entitled to an additional payment of, $100,000, as opposed to we'll pay you 5% of the profit without clearly defining what that is. And even if you define what that is, you get two accountants in a room and they may not agree on what it is.
Right.
So it's really, can you go to an objective measure that, if you go back to the are you smarter than a fifth grader kind of logic, absolutely applies in this instance.
Yeah, that's great advice. And, and profit too. I mean, the new owner can manipulate the profit. I'm not suggesting that they would, right? But, how one owner determines profit could be completely different when somebody else takes over, right? They may add different categories to, the ultimate profit line. And so really, really good advice there. We see earnouts used a lot when there's a value gap. So the owner was hoping to get X value, the buyers are willing to pay Y, and earnouts are used, oftentimes to bridge that gap. Usually in situations where the business has maybe been in decline, or there's a new product or service that the owner had invested heavily in bringing to market, but hasn't seen any of the fruits of all of that labor. And so, they know there's going to be big upside, and the earnout can bridge gaps in those scenarios.
Right. Absolutely.
So let's go to rollover equity. So this could be a tricky one, right? Because is it rollover equity in the sense that somebody's buying the stock and then the owner's retaining a portion of the company, or is it an asset transaction, right? And the owner's being, expected to buy into the new co, right? Those are two very different rollover equity scenarios.
Yeah, and I would be remiss if I claim to know all the tax benefits each way, which definitely behooves working with the accountants and CPAs and tax attorneys on these transactions. But that being said, right, I mean, the concept of rollover equity can take a couple different shapes. Like you said, Dom, you can sell 95% of your stock, in which case you continue to own 5% clearly, or you can sell assets, and then maybe instead of getting $10 million, you take $9 million, and then with that bogey of the other $1 million, you use that to buy stock in perhaps a holding company that was established to purchase the assets. So there are a few different structures that can take, but bottom line, it's you're either paying out of pocket for equity in the resulting entity, or you're just, as you said before, retaining a piece of your prior company.
Yeah, and I think your advice there about you need really a very seasoned and experienced tax person, right, to be involved in those discussions, so you understand and can weigh the differences in the rollover equity, right?
Correct. Yeah. On the corporate side, it's pretty easy, right? You're having a piece of the resulting entity. It's the tax that's the kind of driver of structural type issues there.
Absolutely, absolutely. So moving on beyond business terms, what other areas pop up in a deal that require some real consideration and thought?
Yeah. So you could take just kind of the structure of the transaction. Everybody says, "Oh, I'm closing my deal." There's actually really two parts to that process, right? There's the agreeing on the document, and then there's the writing the check. Oftentimes they happen at the same time, meaning you sign the document and the check is handed off and the assets are transferred or the stock is transferred. But sometimes, depending on the occasion, either a buyer wants to lock in the seller and isn't quite ready. Take the instance where they're getting financing. Or alternatively, there can be kind of regulatory concerns that, okay, we're going to sign up the deal, and if it's a larger transaction, it's getting the antitrust approval, or perhaps there's a government agency that needs to sign off on the transfer. Take it like the selling of a cannabis business in Illinois, right? There's a department in Illinois that needs to sign off on the transfer, and that can take months, frankly. But it's along those lines. So in that instance where there's kind of a third party that needs to step in, or the buyer's not quite ready to do it, most oftentimes because of financing, then it can be what's called a sign and later close, meaning the purchase agreement itself is signed and baked, but the deal closes then at some point in the future.
And in those situations, what are the conditions under which the owner continues to operate the business? Like, are there specific conditions that the owner needs to be compliant with under the agreement that's been signed?
It depends. I mean, I've had transactions where my seller says, you know what, until you send me the wire, you're not telling me nothing, right? And there's usually conditions in that kind of agreement that allow one of the parties or the other to get out. But it's oftentimes, and I think this, Dom, you'd probably echo this. Usually in that case, it's almost like you have a boss, right? So you're the owner operator, but you're not the final decision maker. So let's say during that process, some piece of equipment breaks and it's going to be a $50,000 capital commitment. Hey, new boss. Hey, buyer. This main piece of equipment broke. Should we spend the $50,000? What do you want to do there? So it's kind of I like to think of it as there's a boss that becomes in place that you didn't have before.
Exactly. And really important here that it goes back to picking the right buyer, right? If you don't pick the right partners, that could start to be a problem, and issues can start to arise, right? When you're in that waiting period. So really important that you're picking the right people to do this with.
That's right.
So why don't we move over to representations and warranties? That's a big, meaty topic. Lots of people don't quite understand what that is and what it means. So maybe you can give us a high-level definition, and then we can start to dive into the vagaries of reps and warranties.
Yeah, sure. So reps and warranties are essentially guarantees, and that may be a little bit too strong, but that's how I think it's the right way to think about them. Guarantees that you're providing to the buyer of the business with respect to certain elements of your business. It could be financial statements. It could be about employees. Anything and everything can be covered in reps and warranties. But bottom line, it's you're making affirmative statements about your business to the buyer that in the event they're untrue, there is some pathway for recovery for that buyer. And I think we'll get into that in a little bit, but that's kind of the bottom line on what reps and warranties are.
So maybe we could be illustrative here with the M&A Unplugged audience. Like, what are some of the reps and warranties that pop up that in particular cause concerns for you as an attorney and for the seller of a business?
Yeah, I mean, it part of that is what's the most concerning, depend on what type of business it is. But let's take something like right now I'm handling a transaction where my client is in the limo business, and it is acquiring a competitor. And so clearly here the value is in the customer list. And so part of what my client is paying for is access to these customers. If there's a rep that, this customer list that has been provided is true and correct in, all material respects, and it turns out that 3/4 of the customers haven't done business with that company for 10 years, and that's part of what helped establish value, there's clearly a breach there, and my client, the buyer, is not going to be happy. So just as an example of the kind of thing that you might see.
So let's dive into that a little bit. So where does the responsibility though start and end? So I would assume your client also has to do diligence, right? And so where do you cross the line between did they do the proper diligence or not in regards to whatever the seller is repping and warranting here?
Yeah, well, look, there's a concept called sandbagging, which I think is probably beyond the scope of this particular discussion, but it's an interesting point, right? Because as a seller, you're oftentimes given a due diligence request list that becomes your second job for a period of time. And so that buyer should theoretically know everything and anything. When you're representing a buyer, as the attorney, you still want to put all the burdens or as many burdens as you can on the seller, notwithstanding the fact that it's been an open book or should be an open book as to what you're discovering or not. Sellers would like to take the position that, hey, look, you gave me a 40-page due diligence request list, and I gave you thousands of pages of material. If something doesn't look right, that's on you. So it's part of the negotiation as to kind of ultimate responsibility under the purchase agreement. But, if I'm representing a buyer, I want that buyer to know as much as they possibly can when they're going into the deal, because if all you're buying is a lawsuit, that's a bad idea.
Yeah, exactly. And I think it brings up, a secondary point here, which is diligence. When you're in diligence, you're owner of a business and you're in diligence, it's so important to disclose everything and to catalog everything that you've delivered to the buyer in case there's an issue later on. You can prove, look, we turned over all of this information in discovery. Whether or not the buyer chose to look at it is on them. And this is where, when you work with an M&A advisor, an attorney, and work inside of something called a data room, all of the information goes into the data room and is then made available to the buyer and all of their advisors if they give them access. And critically important, because if something pops up later, you really have given yourself an insurance policy.
That's right. And further to that, you always get the option, or it's not even an option necessarily. Sometimes it's required to prepare what's called a disclosure schedule as part of the transaction. And what that means is, let's say there was a rep that said, I'm licensed to do business in all states, where I conduct business. And it turns out that, you were doing $100,000 a year of business in Texas, but you never registered to transact business there. That would be a breach of the rep and warranty, because the warranty said I'm registered to do business wherever I've done business. So in the context of a disclosure, if that was the case, you might think, what do I do here, right? It's past, there's nothing you can do to fix it. Well, the response is you do a disclosure in the disclosure schedule that says, yeah, I know the rep said I'm licensed there, but I actually never got myself registered in Texas. And what comes out of that is either the buyer says, okay, I acknowledge that, I'm willing to assume that risk, or alternatively, you may have something what's called a specific indemnity to address any liability that could come out of failure to register.
Well, and I think that's a great segue into, so you have reps and warranties, but then they could lead into specific indemnities, right? And so why don't we talk a little bit about that?
Sure. So an indemnity in a nutshell is the obligation to essentially make the other party whole for a breach of some sort. Indemnities are kind of 1-2 with reps and warranties, meaning the part of it is, okay, if there's a breach of a rep and warranty, then that leads to an indemnity, which is, either a cash recovery, or perhaps it's an offset against future payments. If you have, an earn-out type structure, or, holdback or escrow, you can essentially be made whole by taking funds out of those different sources. But indemnities can take a few different forms. One is, again, directly tied to a breach of a rep and warranty. But oftentimes, you'll get kind of blanket indemnities, something that says, I, as the seller, will remain responsible for anything that happened while I was running the business. And so it's interesting when you get unsophisticated buyers, or perhaps buyers that don't pick the right counsel, they will look at the term of the indemnity related to reps and warranties and try and get some caps on it, either by time limitations or dollar figures. And then they forget that there's a separate indemnity that's tied generally to the operation of the business. So indemnities, while reps and warranties are very important, indemnities are even more important, because that's what leads to where the liability and recovery can come from.
Yeah, and so just to drill down a little bit further on this, so you're pointing out between indemnities that survive maybe forever, like if you committed fraud, that you can't put a time limit on fraud, right? I mean, fraud is fraud, and when somebody finds it, they can come back after you regardless if it's 3 days after or 3 years after, correct?
That's right. That's right.
And whereas some other categories might have a specific time limit and a cap on the amount, like you're talking about, that can be recovered.
Right. I mean, in most instances, what's called kind of standard reps and warranties, I see those typically survive for 12 to 24 months. I mean, there are occasions that you'd go shorter than that, and of course longer. But some of this goes to what we kicked this discussion off with, which is kind of what other things other than price are important. I had an occasion where I was representing the seller of kind of a bus company. He ran a school bus kind of operation, and he didn't care all that much about price. He didn't, there were all these things that typically sellers would care about. And all he cared about was that after a short period of time, he wouldn't have to look over his shoulder. So in that transaction, we negotiated that absent, kind of the fraud type things like we were talking about before, that reps and warranties would survive for 3 months. So for 3 months, my client was on the hook for if something arose that was a breach of a rep and warranty, he was on the hook. But 3 months and 1 day, he was done. He wanted to go sit on a beach and not worry about it. So he knew that the money in his pocket was going to stay in his pocket.
And in reality, I mean, that's a very short period of time, right? I mean, when you look at most deals, I don't see reps and warranties that go that short a period of time very often.
But again, it was something that was the most important element to him. In exchange, he probably recovered less cash in the deal that he otherwise would have.
Got it. So I think you're making a great point here. So he traded off something else to negotiate that period down to 3 months, because I mean, in your experience, I know there's no, set time frame, but the range is typically what, in your opinion, when it comes to recovery for indemnities?
12 to 24 months is the standard from what I see.
Yeah, that's typically what I see as well.
But there, there's other things that, sometimes people will create fundamental reps and warranties that will survive longer, or statute of limitation type reps and warranties. And, you typically see that with respect to taxes or environmental type issues.
Right. And if an owner has had some issues in the business, specific issues, those reps and warranties those indemnities might last longer, right? If they've done some things with their books and records or whatever it might be, or tax, you might wind up having those last longer, and other things truncated down to 12 to 24 months.
Right. Or you'll leave it within the reps and warranties, but have a specific indemnity that is not capped by time or limited by time, I should say.
Yep. What other big items outside of price do you see, Jeremy, that might come up?
That's a good question. So it's around kind of liability exposure, things that could be important. You can get into something about, if there's a litigation matter, I'm going to stay local. And I know we'll probably talk more about that in a little bit, but, outside of price, it's take care of my employees. What are you going to do to my reputation? How are you going to roll things up if that is in fact your plan? I mean, it's unique to every particular situation. Sometimes it's how quickly can this transaction happen? Get me out, in 60 days. Dom, as you can attest, I mean, it can be a long process, right? 6 to 9 months is what I see as typical from when somebody decides to do it to when there's a closing. So it's unique to the particular situation.
Yeah, absolutely. Do you see non-compete and non-solicitation clauses causing issues in deals?
Absolutely. And it's funny, depending on the situation, it's either a huge deal or it's not a big deal at all. Going back to my client that I was talking about before that, got the 3-month survival period on reps and warranties. He said, if they don't want me to work all the way to the moon, I'm good with that. Other times, clients have very particular circumstance that they want to be under. So, okay, I will agree not to compete in this one city block radius, but other than that, I'm not agreeing to it. And you can absolutely go to war over this issue, depending on how important it is to the buyer and the seller.
Yeah, and from a buyer's perspective, I mean, look, they're the last thing they want to do is compete with the guy who built the business or ran the business for 20 to 30 years. So as a buyer, they rightfully get concerned when there's so much pushback on a non-compete, right?
Well, right, but it really matters whether it's the type of business that, the former owner was, kind of the business, if you will, meaning that former owner, was the head sales guy, was the operational guy, knew the product in and out, and that it's a replaceable business. I mean, take something like, legal practice, right? Not that that's the typical buying and selling of a company, but in legal practice, it's all relationship driven. So if I go to another firm, maybe you've bought 𝐬𝐲𝐫𝐠𝐞𝐿, but if I go to another firm, I would venture to guess most of my clients are coming with me. It doesn't matter that third party bought 𝐬𝐲𝐫𝐿, right? So in that kind of business, non-competes mean everything. If it's the kind of thing where it's, let's say, an industrial facility that takes millions of dollars to buy the equipment, build the product, send it out, and there's no necessarily identity with that former owner, it might be less of an issue because there's the startup costs and barriers.
Yeah. I see this issue pop up a lot with owners who have lots of patents, who, they're inventors, right? And they're constantly developing new products or whatever it is. And they haven't developed all of those inside of the company. And, but they still have this passion to go do a lot of that stuff and maybe bring something to the market. And they're always wanting to carve out inventions and things that they've created, so they have the freedom to go do that. And the question always becomes, well, is that going to be directly competitive with the business you're selling?
And you know what I see the best way to deal with this, where it's sort of ambiguous whether next act is going to compete with current act, is you get it out on the front end. Hey, I'm going to sell you my home repair business, but I still want to be able to work in, putting up garage doors. I don't know, something silly. But if you talk about that as part of the business terms at kind of the term sheet LOI stage, then it's usually less of a fight than, you're at 11:59 on the day before closing and you say, hey, I want to be able to, do garage doors still.
You spent a lot of money to maybe have a deal fall apart.
Right.
Yeah. I think that's great advice. We recently had a client who I'd put in the category of, the inventor, constantly coming up with new ideas and tinkering with ways to make his products better. And from day one was very honest, said, look, I'm going to carve these things that are not on the market out of the sale. And I expect to be able to, bring these out at a later date. And was very upfront with all the buyers along the way. And interestingly enough, we brought a buyer to the table that was able to strike a deal with the owner where, they collaborate. And so the owner was able to continue to go tinker, but, it was going to get the advantages of this new company being able to mass market whatever he developed. And so it actually worked out to be a great deal for everybody.
That's great. Yeah, I mean, it's something similar. I was representing an auto body shop where it was a husband-wife team. Husband was in his mid-70s, but the wife was in her late 50s. And as part of the transaction, she said, look, I'm not ready to just go golfing every day. I still want to be in this business. And, all she knew how to do was the auto body world. And so the non-compete carved out her ability to consult in the space. Now, she couldn't go out and start another auto body shop, but it allowed her to meet her goals, which are, I want to keep working, and I'm an expert in this area. So,
yep, that's perfect. So, Jeremy, we're going to bring a wrap to this. I feel like I need to have you back though, because there's so much here that we could talk about. But if you were to take, the 50,000 foot level and take a step back for the M&A Unplugged audience, and, what advice would you offer to owners of businesses who are looking to sell about, the topics that we're talking about, when you compare price to terms, and any other, high level advice that you would offer?
Well, the first, and it's not directly related to terms, is realize that selling a business is a second job. So in the context of, negotiating, drafting, figuring out what you're going to do on terms, replying to due diligence, and along those lines, I often hear, how am I supposed to do all this? I still need to operate the business. As Dom, I'm sure you tell your clients, and everybody tells their clients, one of the most important things during this process is to make sure that the business is still functioning on all levels, because until that check's received, there's no guarantee that the deal is done. So that's just kind of one logistical type thing to realize. In terms of of how do you figure out, what's the best offer beyond the price. I think it's important for that seller to think about what things are important to them in the sale. Is it like my client I talked about before? Is it not having to look over your shoulder? Is it making sure that your employees are going to have employment for the foreseeable future? Is it making sure that, your legacy, whatever that may be, continues to live on, either in terms of, quality of product or reputation or market or things along those lines. So I think it's really important before somebody even gets into the entertaining the offers to think, what do I want here? Now, look, this is America, capitalist society. Most of the time, best price wins. But, the question is at what cost, right? If you want to make sure, again, your employees are taken care of, maybe that's not the highest bidder. Maybe that means you go with the strategic buyer, not the financial buyer, or vice versa, depending on who those people may be. So it's an art and a science, so to speak.
Absolutely. That's just awesome advice. Jeremy, it's been a pleasure having you on. If folks in the M&A Unplugged community wanted to get in touch with you, how could they reach you?
Yeah, sure. My direct line is 312-704-2199, or feel free to shoot me an email, which is j.waitzman@sfgh.com.
Jeremy, thanks again. Really a pleasure having you. And I think you shared some awesome information. It's really fun talking to you today.
Thanks, Tom. Appreciate it.
So M&A Unplugged community, let me recap a few things that Jeremy brought up that I think all points back to, please get yourself the right M&A advisors when you get ready to do a transaction. And really, you want people who specialize in this, who do deals day in and day out, because many of the things that Jeremy brought up today are technical and there's so many nuances to them. And if your attorney is not dealing with those day in and day out, you could have something that comes back to really bite you. And we talked about business terms being just as important as price. And two of the things that Jeremy brought up were, are you going to contemplate an earn out? And if you are, having absolute clarity so that you can keep yourself out of litigation down the road. And if you're considering rollover equity, what form is that going to come in? Are you going to retain a portion of the existing business? Are you going to buy into a new co that is formed after the sale? And understanding the tax ramifications of that. The next thing we talked about was structure, understanding what the structure of the deal is going to be. Are you going to do a simultaneous sign and close? Are you going to sign and then are there some things that have to happen from signing to closing? And if so, what happens in that gap? Who's going to operate the business and how is it going to be operated? And are there any constraints on the business? All sorts of things to consider. We talked about reps and warranties. So important. You have to understand that essentially you're going to guarantee to the buyer certain things about the business. And in that guarantee, that's going to lead to you indemnifying the buyer, basically saying, I guarantee these things, and if something goes wrong, I further will indemnify you, and that might come with some recovery or damages. And those have periods that they run, or maybe some of them are evergreen. But understanding all of those nuances is so critical because you might have a great sale, but what good is that if 2 years later the buyer is coming after you for something that you could have been protected for? So great information shared today by Jeremy. Really enjoyed my conversation with him. All of today's information will be available in the show notes. If you would like to learn more about the process of acquiring or selling a business, please visit our website at 𝐶𝐭 or feel free to reach out to me at drinaldi@𝐶𝐭. I look forward to seeing you again on the next episode of the M&A Unplugged podcast. And until then, please remember that scaling, acquiring, or selling a business takes time, preparation, and the proper knowledge.
Thank you for joining us today on M&A Unplugged. If you enjoyed the show, please subscribe, rate, and recommend it wherever you get your podcasts. If you want more great information on how to scale, acquire, or sell a business, please visit our website at SNQ&x.com.